The next case scheduled for oral argument this morning is State of Ohio versus Edwin Rivera, case number 18CA011263. Both parties are here. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve time for rebuttal, please let me know at the beginning of your argument, and I'll keep you apprised of the time, let you know when you're getting close to eating into your rebuttal time. The arguments are recorded, posted on the court's YouTube channel, so please keep your voice up. And we have read the briefs and are ready to proceed if you are.
Thank you, Your Honor. Joe Patituce on behalf of Mr. Rivera. I would like to reserve 3 minutes of rebuttal, if I may.
3 minutes, thank you.
Your Honor, this is an interesting case in the manner in which the case played out. We have the trial court, I think, showing a great deal of concern for the events that were unfolding in front of the court. Almost to the point where I think the trial court was inviting defense counsel on a number of occasions to move for either a mistrial or some type of curative remedy, because we really have almost a duality of ineffective assistance of counsel and prosecutorial misconduct happening, and the trial court is all but saying this is going to be reversed. I think it's at page 189 in the transcript. The judge on day 2 of the trial says we're getting to the point where this is going to come back, because we have the prosecution eliciting hearsay upon hearsay statements, the trial court saying, stop, the prosecutor, with virtually no objection, and then still doing it, even though the trial court has admonished the prosecutor not to do it. So there's that going on. But at the same time, we have defense counsel not objecting, not challenging the hearsay upon hearsay statements, because this is essentially a credibility contest. Did the jury find the alleged victim credible? And if you cut through what the alleged victim herself testified to, that's different than the hearsay statements that are being brought out through the detective, who's being presented as an expert in these types of cases, these types of victim cases. So the prejudice is stark, and it's compelling when you have a detective saying essentially, no, the alleged victim's wrong, this is what she really said, and this is what really happened, which is different than what came from the stand.
Was there a specific expert testimony that you object to?
I would
narrow it down for me as to what statements you feel were prejudicial.
Certainly, it's the victim impact type of comments that came out from the detective, that this is how victims behave, this is how people who are victimized behave, this is somebody with these conditions, what we would expect to come out. That was essentially the detective's main purpose of her testimony, and it went virtually unobjected to by defense counsel. Now, he did object in portions, but and the trial court tried to limit the prosecution. I believe it was on, and I apologize, I normally have my page numbers memorized. I believe it was the 103 to 104 sections of the transcript where the trial court admonishes the prosecution, don't do this, stop, she's not an expert, you never filed a Rule 16K expert report, this person's not an expert, but the prosecution still persisted. They did not back off of that, and that's, when you look at the prejudice, it's the detective telling the jury that this person's a victim, here's her conduct, here's her report of it, and she's acting inconsistently with somebody who I, the detective, believe to be a victim. And Your Honor, I think that's where the specific prejudice comes from, because that, to some degree, almost excuses the inconsistencies that are coming from the stand in the mind of a jury, that, well, we have a detective here, and the detective is saying this is how alleged victims behave, alleged victims act, and the detective going further to say her behavior is consistent with that. So it's that testimony, that line of questioning that is highly prejudicial in many regards improper. Because that also goes into, and I very rarely raise sufficiency arguments, but that goes to the sufficiency. Was there sufficient evidence presented of her substantial impairment? And we don't have a doctor who came in, and it's I think.
You know you don't need one.
You don't need
acknowledge
one, but
that,
you do
correct?
need, absolutely, I believe we acknowledge that in our brief, is that when we lay out the case law here, absolutely you don't need a doctor. You could have a parent, you could have a school counselor to come in and say, this person has an IEP, they have some type of evidence to lead us to conclude that this person is substantially impaired. And in this case, though, we don't have it.
But she
And
testified, correct?
She did testify.
Is that evidence?
Well, it is, well,
I guess what I'm saying is the jury had the opportunity to observe her.
absolutely, the jury had the opportunity to observe her. But when we look at the case law coming both out of the Ninth as well as across the state, just being on the stand is not enough. And I believe that State versus, Hillcock is one of the cases, and that's a 7th District case, I realize it's not the Ninth, that talks about that. And that is a case where the alleged victim, I believe, was a functional 14-year-old, which obviously would be, that's a substantial impairment. Having a 30-year-old being a functional 14-year-old is a substantial impairment, but there was no testimony brought in by a counselor, a teacher, a doctor, a family member to say, this is what this person has, this is what this person, this is who this person is. And I'm trying not to be, I don't want to be insulting towards the alleged victim here at all. It always feels awkward talking about this, but that evidence wasn't brought into the record. And when we read the record, when we read the transcript, there's nothing to suggest that they met that high burden. I think it's a relatively low burden. But there was nothing put into the record to demonstrate that was proven. There was no stipulation. There was no agreement. There was no really reference to it. Maybe, and I understand what the court's saying is that a jury sitting there might look at the alleged victim and say this person is obviously impaired, but there's nothing reflected in the record to show that that's the case. I've never seen the alleged victim. I have no idea. I can't say that just listening would be enough. I sincerely don't know. But what I do know is when we look at the record, there's nothing there.
Counsel, can I take you back for a minute to your hearsay argument?
Yes.
You made some references to other acts testimony that came in through hearsay.
Yes.
What was that all about, and who'd that come in from?
That, I believe, came in, I do apologize, normally.
No, you don't need to. I didn't mean to throw you off. I
believe it was there was an allegation, an unfounded allegation, I believe, that came in through the alleged victim's mother about prior acts that had happened, and I did not focus on that for preparing for today, so I do apologize. I don't want to misquote the record and not give you accurate information, but there was, throughout the trial, multiple instances of hearsay upon hearsay. It's to the point where almost every witness who testified was testifying about what either the alleged victim said or what the alleged victim told her mother, and then that's what the mother said.
But the mother testified for the defense, correct?
Correct.
But it came in the state's case.
Hearsay upon hearsay was coming in both cases, both the state's case in chief and the defense case in chief. That's why I said that to start, this is a relatively bizarre case to handle, because when we read the transcript, I mean, what jumped out at us was the trial court's, I think, correct comments of stop this, to both sides. This isn't a case where the trial court's just calling the state up to say, stop this. He's also calling the defense up to say, I just admonished him not to introduce hearsay or not to ask these questions. Why are you asking these questions now? So that's why we have kind of the dual competing of both prosecutorial misconduct for going too far and ineffective assistance of counsel for not seeking to stop it. I mean, at the point in which the trial court is saying that this is going to be reversed, trial counsel should be asking for a mistrial. He should be asking for, I mean, as a trial attorney, that's most of my practice. If I have a trial court saying, look, these errors are going to amount to a reversal, I think the bare minimum standard is, judge, then we need to make a record of this. We need to ask for either a mistrial or a curative instruction. And I think at the point where the trial court is saying this is going to be reversed, I think he's indicating that because he's already admonished the prosecution to stop, and the prosecution has kept going. Because if we look at the record on the end of the first day, the trial court said, this is hearsay upon hearsay, you can't do this. And then when we came back the very next day, on day 2, the government resumes doing that. I cannot point to any reasonable strategy that the defense counsel would have been using that would have justified either not objecting when appropriate or asking for a mistrial when the court's indicating that this is troubling. For instance, when we look at the double hearsay chain when the victim had said essentially nothing happened, the detective testified that the mother, and this is at 214 in the transcript, the detective says, no, that's not true. The mother says that she said this happened and this is how it happened, and that's consistent with victim impact, or victim testimony would be, or victims would behave. Not a single objection was made to that. The trial court then pulls the parties up, and it's at 214 and 215, and it says, stop this. We've talked about this. You can't bring this out. And at that point, any reasonable trial attorney would have either asked for a curative instruction. I would have personally have asked for a mistrial at that point. And it's always tough because I'm not criticizing the attorneys themselves, but having been both a prosecutor and now as a defense attorney, I don't think it would have ever gotten this far because we would have been objecting well in advance of this. And that's what's so stark about this case is that there are very few objections that were actually on point for the hearsay problems and for the prejudicial bolstering issues. For instance, under 608, the defense allowed the prosecution to run roughshod over her credibility by talking about her truthfulness and that she's honest, and that's improper. And there was virtually no objection to that. It was the trial court, and I think the trial court did everything it could do short of sua sponte declaring a mistrial himself. Because
What about any curative instructions given sua sponte?
Could have. There was. The trial court actually mentioned that. He said, I should have given a curative instruction yesterday, but it's too late. And that was part of that discussion. He said, I should have stopped this yesterday, and I should have given a curative instruction.
You have a total of 345, so if you want to move on to a different argument, I want to give you that opportunity.
Any other questions? Otherwise, I would like to reserve.
No, I don't want to take up your time. I'll read the record.
You have 3 minutes and 30 seconds then for rebuttal.
Thank you.
Good morning, Your Honors. Lindsay Poprocki on behalf of the appellate state of Ohio. As the appellant's counsel indicated, his first three assignments of error are somewhat interrelated, and that is a challenging improper testimony that was admitted by the trial court, and that the defense counsel was ineffective for failing to object to a portion or a bulk of that testimony, and that the prosecutor engaged in misconduct in eliciting some of that testimony. In making his first assignment of error, Rivera asserts that a number of the testimony elicited by the state was hearsay testimony, that improper expert testimony was elicited from the detective, the state elicited improper testimony as to the victim's truthfulness, and improper victim testimony. At the outset, though, the state notes that Rivera's arguments can be categorized as an attack on the trial court's admission of evidence, which is typically within their sound discretion. As Rivera conceded in his brief, however, in making his ineffective assistance of counsel argument in his second assignment of error, his counsel did not object to the bulk of the contested testimony at trial. Here, the trial court's review then is limited to plain error. Rivera failed to argue plain error in his brief, and the trial court, this court has repeatedly noted that it will not sua sponte fashion an unraised plain error argument on appeal. We nevertheless dispute the merits of Rivera's arguments. As to challenge hearsay testimony by the detective, the first portion of her out-of-court statements relate to statements made by the victim during the course of a police investigation. As it relates to that testimony, it is well settled that statements offered by police officers to explain their conduct while investigating a crime are not hearsay because they are not offered for their truth.
Well, counsel, in fairness, that law has been interpreted as we got this call and this is how we ended up at this scene, or this is why we talked to this person. Isn't there also case law that says you can only take it to a certain point? You can't say who the person is. I'm not quoting that exactly, I'm sorry, but didn't this go too far? If you're going to put it under that category, that, you know, police, the progress of the investigation, is this, her statements, the interview with her included in that case law?
I believe that if those statements are included in the course of the investigation, if those statements were not included in Detective Dietschy's course of in that within that case law, then we would turn to the fact that the victim herself testified at trial. And any statements that she made were subject to cross-examination, and there was no error, there was no harm in the statements being admitted by the trial court. Therefore, the general purpose of the hearsay rule was not undermined by the fact that the victim testified at trial and was subject to full cross-examination. And the same holds true for the testimony of the mother. Here she testified on behalf of the defense. Assuming arguendo that the admission of her statements to the detective were error, such error was harmless in light of the fact that she testified at trial on the same facts contained in the purported hearsay. And as to the detective's purported expert testimony, here the detective testified at length as to her experience, training, and education regarding sexual assault investigations. And that is a proper way to categorize a person as an expert under 702B. There's a case I cited in my brief, State v. Solither, where a police officer was properly found to be an expert to testify on matters regarding sexual assault investigations because of his lengthy experience as an officer involved in sexual assault investigations. So we would also submit that that testimony was properly admitted.
What's the case law on if a police officer is used as an expert, the requirement for the exchange of a report or the identification of that witness as an expert? Is there any case law on that point?
I did not prepare that with my brief. And then in regards to his ineffective assistance of counsel argument, that is based in large part on counsel's failure to object to the evidence that he claims was improperly admitted, and Rivera claims based on that his counsel was ineffective. Here Rivera must claim that his counsel was deficient. He must show that his counsel was deficient, that he was prejudiced by that deficiency, and overcome the strong presumption that his counsel's action was sound trial strategy. As to the failure to object the objective purported hearsay statements, this court has consistently held that trial counsel's failure to make objections is within the realm of trial strategy and does not constitute ineffective assistance of counsel. And just as importantly, failure to object to hearsay statements has been found to be non-prejudicial where the declarant testifies at trial and is subject to cross-examination. Again, the victim testified at trial. And like the decision to object, whether to move for a mistrial or a curative instruction also falls within the ambit of trial strategy. And because Rivera failed to show that his trial counsel's decision not to object, not to request a mistrial, or request a curative instruction was anything other than trial strategy, he cannot show that his trial counsel's performance fell below an objective standard of reasonableness, and therefore the first prong of the Strickland analysis has been failed to be met, and the court need not indulge in a prejudice analysis. As to the prosecutorial misconduct claim which Rivera alleges, he has the burden of demonstrating that but for the prosecutor's misconduct, the result of the proceeding would have been different. Here, Rivera argues that the prosecutorial misconduct resulted from the same grounds that his first assignment of error is based upon. The state would note, however, that again, his trial court did not object to the testimony which his first assignment of error is elicited upon. Because Rivera failed to object to this line of questioning, he has forfeited all but plain error. Again, Rivera has not argued plain error on appeal. As a consequence, this court should decline to construct an argument regarding prosecutorial misconduct on his behalf. Regarding Rivera's arguments regarding the sufficiency and manifest weight arguments, the evidence does not support either one of those arguments. Rivera attacks the evidence used to convict him as alarmingly shallow, and also attacks the credibility of the victim by calling her confused and dishonest. And he also challenges the fact that there was a lack of physical evidence here. He presents no case law to say, though, that physical evidence is necessary to uphold a conviction for sexual battery or gross sexual imposition, and the case law provides the opposite. This court has noted that while physical evidence would be strengthen the reliability of a victim's statements, it is not necessary. And in making credibility assessments, a jury has the right to place considerable weight on a victim's testimony. In this case, the jury simply chose to resolve any conflicts in the trial testimony against Rivera and in favor of the state. The jury was in the best position to weigh the evidence and determine the credibility of the victim and the defendant. And in terms of the sufficiency argument, Rivera has argued that the state did not prove that the victim was substantially impaired. And as the court is well aware, the term substantial impairment is not defined in the Ohio Revised Code, and therefore it must be given its meaning in terms of the common usage. The Ohio Supreme Court has noted that this is established by a reduction or decrease in the victim's ability to think, and it does not have to be proven by expert testimony. Rather, it can be shown by testimony of people who have interacted with the victim, and may also be proven by the victim's own testimony. The most important evidence here of Gio's substantial impairment came from her own testimony. She testified that she had a learning disability and that she received disability benefits. She also testified that she graduated high school at the age of 20. While in high school, she testified that she was in an ED class, which was a course for individuals that needed help because they didn't know how to write and couldn't spell. The detective and SANE nurse also testified as to her cognitive disabilities. Here, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found that the state proved her substantial impairment beyond a reasonable doubt. Based on those factors, we would ask that the court affirm Rivera's convictions and sentence.
Okay, thank you very much.
Thank you.
And as I said, you've got 3 minutes and 31 seconds. Comment on the argument the state has made about plain error and that not being raised in your briefs, in addition to anything else you want to say.
Certainly, that's actually one of the first things I have right down here. I do know that I should have noted that and addressed that initially, but we have raised our objections to the prosecutorial misconduct. We have raised it to ineffective assistance. There's no further need to set out a separate section that says plain error. I mean, it's incorporated in it. I mean, That's what ineffective assistance of counsel often is, what prosecutorial misconduct often is. And when we read the case law out of this district, the Supreme Court, it's all referencing the standard, and this court knows what the standard is, and three very experienced judges. There's no need for us to set forth a separate plain error argument when we've already argued the specifics of prosecutorial misconduct and ineffective assistance of counsel, and I think the case law is clear on that. Going backwards now, State versus Daniels, which is a 9th District case, lays out the substantially impaired, and it lays out the differences here. As the prosecutor mentioned, the alleged victim in this case was a high school graduate. She worked a full-time job at Bob Evans. The only testimony that came out about her impairment was from her mother that testified that she had difficulty with spelling and penmanship. There was no further testimony from the detectives regarding her disability. They certainly had ample opportunity to do so. The same nurse actually testified for the defense. The same nurse testified at 282 through 293 that there was absolutely no evidence to support the allegations that she was making. There was no testimony elicited from that nurse regarding, and that was a defense witness, but there was no testimony from that witness regarding cognitive impairment. But coming back to, I think it was a question you had asked, Your Honor, what's the case law as police officers testifying as experts? And that's important here because there's a distinction here. Under 702, often a police officer might be able to testify to areas that are within the realm of police officers, such as like a drug case or a gang case. The trial court got it right here and warned on page 235 that this person's not a doctor. You're seeking medical expert testimony from the detective, and that's different than having a detective testify that what a hand-to-hand transaction is or why someone might have 2 cell phones in a drug case. That's standard police type, that's within their wheelhouse. That's what, I think every police officer can testify to that if you can lay the
Well, does it
foundation.
matter what experience, training, credentials have? Is it a case-by-case analysis based on experience, training, et cetera?
It is to a degree, Your Honor. When we're talking about evidence that's in the normal experience of a police officer, and here, when we look at the testimony that came out regarding this detective's training, she wasn't able to offer any specifics. And when asked, can you define what delayed disclosure is, she was unable to define what delayed disclosure means, and this is a delayed disclosure case. And I believe that happened at, I forgot to write the page number down, I apologize.
Well, counsel, part of it was delayed disclosure, part of it wasn't, right?
Correct. But when we're talking about the expert, the 16K analysis, you have a witness on the stand who can't tell us what a delayed disclosure is. And that's, to me, that's troubling. You're being asked to testify as an expert, but you can't testify to one of the basic.
No, you keep going.
Basic.
You're seeing my wheels turn.
I learned very young whenever I see a judge lean forward to stop and expect a question.
Counsel,
You-
all right,
you
I do have a
as he's
question.
out of time, but I'm going to let you ask the question. Go ahead, Judge
Does
Gillen.
If your client testified, correct?
Yes,
And admitted the sexual conduct, correct?
to a degree, yes.
I mean, he said it was consensual, but
Right.
admitted it. Does the delayed disclosure or any of that even matter under those circumstances? The substantial impairment certainly does. That's part of the element of what he was
Right.
convicted of. But do they matter? Does that matter?
It does, Your Honor, because when you look at the testimony of the detective as a whole, and I realize I focused in on just the delayed disclosure part for argument here, but when you look at the testimony of the detective as a whole as to victim impact, victim behavior, when you take that as a whole, it is highly prejudicial, because if his position is it was consensual, she was able to consent, she's a person who can testify here that I knew what was going on, I was aware of it. The detective is essentially being used to attack the state's own witness, and as an expert, as somebody who's being held up as somebody who is at the pinnacle of the profession. So in that regards, it does matter. Now, does the technical limited delayed disclosure part matter? Not as much, but I'm just using that as a way to illustrate how the detective was used improperly as a whole.
Thank you.
And with that, your time is up. So I want to thank you both for your presentations today. The court obviously is going to take this matter under advisement and will issue a decision in due course. The clerk of courts will mail each of you a copy of the decision on the day it's released, and you can also keep an eye out on the Supreme Court of Ohio's website where the opinions are also posted. Thank you once again for your arguments.